So, welcome back to another podcast and YouTube episode. We tend to do both so that we cover both areas. And today I'm super excited to be joined by Joanna Sutton. So, hi, Joanna.
Hi, thanks for having me, Trish.
I'm more than welcome. So, Joanna is an amazing employment lawyer who I had the pleasure of meeting. Oh God, don't know how long ago it was now. A good few months ago, wasn't it?
Yeah, last year sometime. I feel like
Yeah.
it was summer sort of time.
I feel like it was warmer, and we went
Yeah,
for an interesting networking event where we were doing clay pigeon shooting, but wasn't clay pigeons because it was digital. Is that right? I'm not really sure.
yeah, but the guns were still heavy and real.
Yeah, they were, but obviously not real. It was all digital for our listeners. But on meeting Joanna, I just thought doing a podcast with her would be excellent because she's super experienced at what she does, very clear when she explains things, and that's going to be super helpful for our listeners. So Joanna's been doing a thing for kind of 7 to 8 years with Nockolds. Obviously, you can see the logos on the screen. You work both with businesses and individuals on work-related matters. Is that right?
Yeah, that's right. The full kind of spectrum of everything employment and work related for, yeah, both sides.
Oh, fabulous. So a brilliant expert to have a chat to. So we've got about 6 cases that we're going to have a chat about that are interesting from both an employer and an employee perspective. So we'll have a general chat and hopefully give you some kind of takeaways and things that you guys need to be aware of from those cases. So first one centres around reasonable adjustments in a recruitment process. So in this case, I hope I'm saying it right, I've got AECOM Limited versus Mallon. Here we've got a chap who applies for a job. He lets the HR department know that he has dyspraxia, and actually he's not great at filling in application forms, so he wants to send in a CV instead. So I would see that as a reasonable adjustment. The HR team kind of acknowledged that there was an issue and said, if there's any problems, let us know, but you do need to fill out the form. And long story short, that kind of resulted in a disability discrimination claim. So for those people who don't know what we mean, how would you describe a reasonable adjustment to start off with?
So, I mean, it's basically anything that can assist somebody where they have a disadvantage in performing, the work that they're required to do. So it could be, for example, if you had a physical disability and you worked in a factory, for example, making sure that the kind of aisleways in between machinery and things like that are wide enough to get a wheelchair down, that would be a reasonable adjustment to make. So
Mm.
it's just something that can take away that disadvantage that the employee might be experiencing as a result of a disability that they have. And I mean, for a disability, it might be worth touching on that as well.
Mm.
A disability for employment law purposes isn't quite the same as it is in a sort of real world example of disability and what people might think of. But for employment law purposes, it's a physical or mental impairment that has a substantial and long-term impact on an individual's ability to undertake normal day-to-day activities. So it's basically something that has lasted or is expected to last for at least 12 months that has a real impact on how you live your life. So it might be affecting you, I don't know, being able to get on the bus or go shopping, answer the telephone, things like that. So quite different from how people sometimes think of a disability in, normal day-to-day life.
And also, I think the thing for me with that definition is it's so broad,
Yeah.
isn't it? That could encompass so many different things. And I think that's definitely something that employers always miss.
Yeah, absolutely. I think that, that, as I said, that tends to be people think about that physical
Mm,
disability, perhaps.
mm,
And, there are things like cancer, for example, is automatically classed as a disability, which, people may not necessarily even think of that. And there are cases, some of them that we're going to be talking about today that are decided all the time that really stretch that definition. And
mm.
things like this case, for example, with the dyspraxia and those kind of dyslexia, those kind of things, these new ideas around disability are being introduced all the time. And so employers may not automatically think, yes, that's a disability that I need to consider making some adjustments for.
It's a really good point. So what can people learn from this one then? What would your advice be in these sorts of situations?
Yeah, so this one I think was, I mean, for a start, he wasn't an employee of this company. So some people think that actually you only have that obligation not to discriminate against somebody or to, to make those adjustments if you've got somebody working for you. But in this case, the claimant bringing the claim wasn't even an employee. He was applying for this job and disclosed, yes, he got dyspraxia and he wanted some adjustments to be made to the recruitment process. And although the HR manager responded and, offered some assistance, the Employment Tribunal just found that actually that wasn't broad enough, particularly in circumstances where he'd specifically said, I've got dyspraxia, and that then affected his ability to, to comply with their application process. And I think that this is really something that there's going to be sort of more developments in this area, because people, as I say, are coming forward and saying they've got these disabilities, and that there are adjustments that need to be made accordingly. So in this case, what the tribunal found was that actually, he had asked for a telephone interview, or to be able to, as you said, submit the CV, and that the HR manager went back via email rather than, in the forum when he was saying he'd got dyspraxia, which actually meant that he had difficulties in communicating, with written communication. They found that what they should have done is pick the phone up to him and talk to him a bit more about the difficulties that he was having. And if they had done so, they would have realised, the adjustments that could have been made to mean that, he had a fair chance at applying for the job. So in this case, the decision was that they didn't make enough reasonable inquiries into the difficulties that he had to make those adjustments, and that really they should have made more effort to do that in these circumstances. So I think it really reinforces the need for employers to be very cautious when dealing with somebody with a disability. I think that sometimes people don't want to ask questions because they're worried about saying the wrong thing. But actually, this case really highlights that actually you need to make those inquiries, because the law says basically that if an employer knew or could reasonably be expected to know that someone has a disability, then that's when the duty to make reasonable adjustments kicks in. So the fact that this guy had disclosed, I've got this condition, they should have asked more questions about it to actually assess whether or not it was a disability, and if so, what adjustments could have been made. So it's quite a harsh decision. I think in quite a lot of ways, people will probably think that it was probably, quite onerous on the employer just to have that one email saying, I've got this condition, can you do this instead? And they were maybe thinking they were acting reasonably because they're treating everybody the same by saying, this is our online application process, this is what you have to do, and they assess everybody in the same way. But in this case, it was, that wasn't found to be reasonable, and adjustments should have been made. So I think it's quite a sort of, people would see that as quite a harsh decision. What do you think?
I think the issue with this one is people just don't realise what the obligation is. I think that initial point that you touched on around people not realising that even though this person isn't an employee, they're still able to make a claim, and also the impact of the small things, right? Just picking up the phone and just having a chat with this person, regardless of the condition that they've got, really, like just figuring out kind of where they're at and how you can support would have made all the difference in this case, right? So it's the small stuff that people, in my view, need to kind of pay attention to. But equally, I think that point around, people not realising how broad the legislation is, I think is an important one to hammer home. So it's interesting, super interesting.
Definitely, yeah.
Number 2. So this one is an interesting case around sexual harassment. So this is Finn versus the British Bung Manufacturing Limited. Interesting company name. So Finn was an electrician, had worked for the company for 24 years, but no problems or no issues up to that point. There's then a couple of heated arguments that take place, and Finn is dismissed. But during one of the arguments, he's called a bold, and I'm not going to say what the following profanity was. He then brought a case saying that kind of he had been sexually harassed, which is an interesting case. Although I don't think, you can correct me if I'm wrong, I'm not sure we'd seen anything like this before. And basically this kind of centered around boldness being something that is linked more to men than women. So therefore calling him bold and a profanity was actually something related to his sex. So it was actually sexual harassment. So it's super interesting because we've not seen anything like this before. What do you think of this one, and what are the takeaways for people?
Yeah, definitely. A really interesting one, because I think that when people think about sexual harassment, you think about that kind of classic situation where a woman is being sexually harassed by a man, and that is what you tend to think. But actually, from a legal perspective, the definition of harassment, and I'll read it because it's quite wordy, is unwanted conduct which has the purpose of violating an individual's dignity and creating an intimidating, hostile, degrading, humiliating and offensive environment for them. So you can, in that sense, calling somebody a bald profanity is obviously not very nice. I think in this case, the person who called him that was actually a supervisor working for the company as well. So, not the behaviour that you would expect a supervisor to act towards a member of staff. But what was key in this case was that behaviour had to be linked to the individual's sex, so it had to be related to him being a man. And the courts really kind of tussled with this and talked about whether or not baldness was inherently something that men would experience. And I think quite often we see a lot of as you say, it's unusual because these cases tend to be the other way around, when we're talking about things like does the fact that somebody worked part-time relate to their sex as a woman, because a woman traditionally has childcare responsibilities, that kind of thing. In this case, they considered the fact that yes, some women are bald, sometimes that's through choice, sometimes it's medical condition, alopecia, that kind of thing. But generally speaking, they found that baldness was more likely to relate to somebody being a man than another sex. And so that was effectively the tick in the box that they needed to say this is sexual harassment, and so the claim was successful. So I think, again, really surprising case that people wouldn't necessarily think on the face of it that would be sexual harassment, because it doesn't maybe fit that kind of classic definition. And it's also really relevant because this was another member of staff making the comment to their colleague, and not the company, the employer themselves making the comment. And I think, again, what people don't realise is that an employer, the company that employs these people, can be found to be liable for the acts of the employees that are done in the workplace. So in this case, even though it was nothing to do with the company or a director or something like that, it was just another colleague saying something to another colleague, that was still found to be sexual harassment that the employee was responsible for. And so I think it's really relevant that people realise that actually this kind of I hear it all the time where people are like, oh, it's just banter, that creates an offensive culture. And I think that the way that, things are modernising, that this kind of, behaviour may have been quite commonplace, where, shouting insults, swearing, making offensive comments may have been more commonplace, but now it's just not acceptable in the workplace. And so one of the real takeaways for me is making sure that, from a culture perspective, that employers are sort of acting upon these comments being made. The first time it was made, it should have been nipped in the bud, and it shouldn't have been something that then happened again, and really then kind of compounded that, creating that offensive environment. So one of the things that I think is really important is that employers are training their workforce on what is acceptable and what isn't. And I think that is so often overlooked, but it's really important, because one of the first things that an employment tribunal will look at in a case like this, or a discrimination case, is what's your policy about equality in the workplace, about bullying, harassment. Show me the written policy that you have that shows what you do in those circumstances, which sometimes companies just don't have. And the other thing that they ask is, when did you last train your workforce about what is and isn't acceptable? And those kind of opinions, as I say, change over time. What was acceptable 20 years ago is definitely not acceptable now, but even what was acceptable maybe 5 years ago has changed now. So training and keeping that kind of knowledge is so important, and it's really important from an employer's perspective, because there's a potential defence to a claim like this if you can show that you have taken all reasonable steps to avoid the bad behaviour happening in the first place. And that would be, we train our staff, we have a policy that makes it clear that we don't accept behaviour like this, we pull people up on it when things like this happen. And so all of those things are steps that an employer can take, which would then really put you in a much better position to be defending a claim like this.
100%. And I think, exactly as you said, I think the world's changing and moving and shifting at such a rate. If we can do things to support our employees who probably aren't 100% sure what they can and can't say at any given time, I think that's really, really helpful, personally. Obviously, you can't make people learn things, but you can provide those opportunities for people to come along and have the opportunity to get information, which I think is super important, really, really important. And I
Yeah.
also think the policy point is a really key one, because when I'm doing my private work with my clients, I'll often speak to people and something's happened and they're like, okay, well, we need to do something. Like, okay, well, where's the policy? I don't have one. Like, it's so important to get that stuff in place up front. yes, you might have a happy workforce right now, but you never know when something's going to happen. And it's important that people know where the line in the sand is in terms of how they're going to be treated and dealt with when something goes wrong. So, yeah, totally with you on that.
Absolutely. The other interesting thing about this one that I read was that the tribunal members, so the judges that made the decision, there was 3 of them, which there always are in these types of cases, they were all bald, they were all men, and they were all bald. So I wonder if there would have been a different decision if that wasn't the case, if the judges were women, perhaps. I don't know.
Yeah, no, it's interesting. I think it's quite interesting in how the link's been made, but I'd like to think the decision wouldn't be different. But yeah, you never know. It's kind of who's on the
Yeah,
panel on the day, right?
definitely, definitely.
Cool. So our next one then is agency workers applying for jobs. So I want to switch this up a little bit. Do you want to tell us a little bit more about that case, and then we'll have a chat?
Yeah, sure. So this case, the guy who brought it was employed by an agency and was doing work for Royal Mail, and the company had a policy of announcing the vacancies, but they didn't let agency workers apply at the same time as they let everyone else who was directly employed by Royal Mail. So they'd say, hey, we've got some vacancies coming up. They'd tell everyone, but they wouldn't let the agency workers apply at the same time as the rest of the employees. And so this individual brought a claim saying actually that was a breach of the agency worker regulations. And there's a specific part of those regulations that say that agency workers have a right to be notified of vacancies that are available at the company that they're working for. And he argued that there was a right that they should that implied that they had a right to apply for those vacancies alongside everybody else. So quite an interesting sort of niche point about something that was not expressly in the legislation, but yeah, said that it had been implied, and essentially the tribunal found that no, that isn't what sorry, the first instance, the tribunal said that there had been a breach of the regulation, and then there was an appeal, went to the Employment Appeal Tribunal, and they said, no, the law just says that you have the right to be informed of the vacancy, but it stops short at having a right to apply for the vacancy.
Mm,
So quite a sort of a technical point, I
mm,
guess.
mm, mm.
What do you think, Trish?
So I suppose I'm going to answer a question with a question, which I know isn't the best. But I suppose my kind of natural instinct with these sorts of things. So when I'm doing my job as a CPO and I'm advertising roles internally within the organisation, I would give everyone the opportunity to apply all at the same time. So I suppose this one kind of questions that kind of natural instinct for me. So
Yeah.
should I be doing that, or if I do that, should I be holding back the applications from agency staff? And then I'd be worried if I'm doing that, I'm being discriminatory in some sort of a way. So I guess for me, it's an interesting case, and obviously very, very technical. But where does that leave HR people or business owners? What does that mean we should or shouldn't be doing to make sure we're doing the right thing?
Yeah, absolutely. And I think, like you say, the way that the employment law has evolved is essentially treat everybody the same. And,
Hmm.
this is effectively saying, yeah, but you don't have to treat, them the same in this way, which I think can then get quite confusing because
Mm,
it
mm,
also opens up the potential for, yeah, there to be distinctions made, for other reasons or, on other basis, which is just then from an HR perspective, just a bit of a headache and a minefield to consider. And I think as well, it's really relevant because, especially at the moment where there's quite a lot of redundancies and stuff going
mm,
on, in a redundancy situation, when you are trying to avoid a redundancy and you look at other vacancies within a business, most employers, I think, would be sort of more, they would prefer to keep their own, directly employed staff to offer them those suitable alternative vacancies. And
mm,
so I think
mm,
that's something that probably happens, quite frequently, that they say, oh, you're at risk of redundancy, but we've got these other roles. Do you want to take any of those? And so that is one of those examples where perhaps they wouldn't be opened up to agency workers because the agency worker, then they wouldn't have to pay them redundancy pay and things like that. It's an additional cost to the business. So if you can keep your directly employed staff within the business and you want to retain that talent, especially with all the stuff we've had over the last, couple of years with the difficulties of recruiting and, all the
mm,
rest of it, that is perhaps an example of where that distinction might be made. But I think this case has been appealed and it's gone to the Supreme Court, which from an employment law perspective is always really exciting, because we don't get that many cases that go that far. And I think the decision was being heard at the end of last year, but there's no decision that's come out yet. I haven't seen anything anyway, so it's definitely one to watch, because it may be that it flips on its head again, and that they suddenly, you know, you should be treating agency workers in the same way as directly employed staff. So definitely one to watch, I think.
Yeah, no, I'm excited to hear the outcome of that as well. The things that you and I get excited about, hey?
I know, exactly. It's very exciting.
Oh, cool. Alrighty, so next one then is around not coming into work during COVID, or due to COVID kind of scares, I suppose.
Yeah.
This one is Rodger versus Leeds Laser Cutting, and effectively, as I said, he was dismissed because didn't want to return to work due to kind of COVID-19 safety concerns. So this person didn't have 2 years service. So what's significant about that for everyone who's listening?
Yeah, so it's one of the first things that I always ask when actually I'm asked, you know, advice about employment law situations. How long have you worked there? How long has the employee been with you? And it's relevant because that's when quite a lot of employment rights kick in. So most importantly, the right not to be unfairly dismissed. You can't bring a claim for unfair dismissal unless you've worked continuously for the same company for at least 2 years. You don't have the right to redundancy pay, you know, various other rights don't kind of kick in. So it's really relevant when you've got an employee who's been dismissed, that then you look at, yeah, how long have they been working? And I think this guy had been there for less than 2 years, as you say, but then had been dismissed because he had refused to return to the workplace because of concerns about COVID. And so he then looked at what claims can I bring in those circumstances, and he brought a claim for automatic unfair dismissal, which doesn't have that 2-year requirement. You know, anyone can be automatically unfairly dismissed, and there's various grounds that, you know, have to be relevant, but in this case it was on the basis of raising health and safety concerns. And he said, yeah, he was automatically unfairly dismissed. It's quite complicated, but it's basically, if you are complaining that you were in circumstances of danger that you believed were serious and imminent, that you couldn't be reasonably be expected to avoid, and that you left your workplace as a result of that, and then you were terminated, that then triggers a potential claim for automatic unfair dismissal. So quite a sort of technical one, but quite a lot of cases around at that time. You know, certainly this happened, I think, during the very first lockdown. So at that very early stage where, you know, everyone was extremely concerned about their health and safety. And I think that this guy had said he didn't want to come in because he'd got vulnerable children. He was concerned about infecting them. So legitimate concerns, as many people had at that time. And it's taken quite a long time for these cases to work their way through the Employment Tribunal because of delays in the system. And so, you know, it's surprising that, yeah, we're talking about something that happened in the first lockdown, but it only was heard by the tribunal last year. But yeah, in this case, it's gone through, you know, an Employment Tribunal, an Employment Appeal Tribunal, and a Court of Appeal decision. And I don't know if do you want to talk through the outcome?
Yeah, go for it. I love listening, so go for it.
Oh, brilliant. Okay.
I'm learning.
So yeah, the case ultimately was not successful. They found that he wasn't automatically unfairly dismissed, and that was basically because that kind of complicated definition of what would amount to an automatically unfair dismissal wasn't made out, because although he had genuine concerns about COVID and the impact that it could have on his children and everything else, the tribunal found that he could have avoided the danger because the employer had gone quite a long way in putting, you know, various measures in place to protect their staff. So I think it was a manufacturing business, and so they wanted to continue operating during the lockdown. So they put things in place like social distancing and masks and sanitizing and staggered start and finish times. And the tribunal found that actually they had done as much as they really could do to protect their workforce. So although the employee had a genuine concern about COVID, that the measures that were put in place were sufficient to mean that he could have avoided the danger that it presented. So I think that it's, as I say, another kind of technical one, but it really is, it's relevant in terms of, thinking about, there'll be a lot of cases that we're probably still going through the Employment Tribunal for very similar circumstances, and it set out sort of a new relevant definition about the danger and, the reality of that danger. And it also made clear that that had to be related to the workplace. And I think that that's quite relevant because here, otherwise it could have been that, just the existence of COVID was enough for no one to go to work, and that would have just meant that, the country would have ground to a halt even more than it already did. So yeah, quite a sort of a technical case, but yeah, interesting if we think back to those dark days of COVID.
Yeah, and obviously not wanting to be kind of ominous in any way. COVID is kind of on the rise at the moment, right? So we may start to see these sorts of things coming back up. And I think
Absolutely.
it's super interesting because, initially the concern that this chap had is, like you said, a legitimate one. And how do employers respond to that legitimate claim without kind of stopping, running their businesses? So I think it's quite interesting, the nuances that you get with that one. And hopefully, touch wood, we won't see any more. But as you say, it's useful to have that kind of test case, isn't it?
Yeah, definitely. And I think the other thing it highlights is the importance of communication, which is what I, hear so often from, when I'm advising an employee, they'll kind of say, well, if only my employer had said it like this or they'd done this, it really shows the importance of, if the HR manager or whoever had said to this guy, what are you concerned about?
Mm.
And he said, explained his position, and then they could have talked through with him, actually, this is what we've done, these are the measures we've got in place, is there anything else that we could do? Again, making those kind of adjustments and talking it through and kind of reassuring the employee, I think, would have been key here. I think one of the things was that there was just no communication between them. He said, I'm not coming back until lockdown eases. He was off for about a month or so. The employer got fed up and then dismissed him, thinking he's got less than 2 years service, we don't need to, follow any procedure. And really, yeah, highlights the fact that that 2-year rule that so many people are aware of and kind of rely on isn't going to be foolproof in all circumstances. You can still bring claims like this. You can still bring claims for discrimination or whistleblowing. So yeah, I think for me, it really highlights the importance of communication and just talking to your staff and being seen to, to answer their concerns and be, conscientious about it.
No, totally agree. Alrighty. Next one is around menopause and disability discrimination. And actually, there's a lot of stuff about menopause in the press of late, so I was quite excited to be able to chat to you about it. So this one is Lynskey versus Direct Line, and apologies if I've not pronounced that correctly. So this one is kind of around reasonable adjustments again, but obviously linked to menopause. So in this case, we've got an individual. She's a good performer, but when she starts to go through menopause, she feels anxious. There's issues with low mood, poor memory, brain fog, the things that you would generally associate with going through the menopause. Obviously, those things started to affect her job and her ability to carry out her role. And then having a chat with her line manager, they decided to kind of transfer her to another position. That still doesn't work out. She's still not really hitting her targets. And long story short, she ends up getting a disciplinary warning. She is sent to occupational health, who say, caution here because this person might be disabled in the way that you described earlier with that definition. Do you know what? You might need to fill in the gaps here for me because I don't know why, but her company's sick pay is withdrawn at some point, which doesn't make any sense to me after she gets signed off sick. She raises a grievance and she resigns. So I've massively simplified that case. She then brings multiple claims to the tribunal, but one of them being that failure to make reasonable adjustments for the fact that she is disabled. She gets not shy of 64 grand as a payout, which is massive.
Yeah.
And then also a payment for aggravated damages. So it would be great to talk a little bit more about what that means, because that's quite an unusual piece to this puzzle too. So if I missed anything, and what do you think about this case?
Yeah, so I think you've summarised it really well. I think that the sick pay was withdrawn, and I think that's another thing that kind of links to, you know, the employer's attitude here. They basically said they had a discretionary enhanced sick pay, so they could pay her full pay if they wanted to, and they did for a while, but then they decided to withdraw that because they said that she wasn't doing enough to improve her own situation, and thought that she was just kind of malingering, you know, off sick. So again, not very supportive of her at all, and kind of, yeah, then that added to the claims that she had. So I mean, from an employment law perspective, there's been quite, as you say, a lot of talk in the press over the last couple of years about menopause, and there was a sort of a campaign for it to be added as a protected characteristic in itself, so that, you know, it was one of those categories like disability or age or sex or that kind of thing, that, or, you know, would classify it as a disability, as a protected characteristic. The government decided not to go that far at this stage, but it can, as you said, fall within that definition of disability on the basis that it's a, you know, has a severe impact on your ability to undertake normal day-to-day activities. And the Employment Tribunal's decision here in terms of whether that was disability discrimination and whether they should have made more reasonable adjustments was they should have done, the employer should have done more than they did. They should have, you know, thought about her menopause having that impact on her performance during the disability, the process where they gave her the warning, rather than just saying your performance is no good, you know, you're suddenly making all these mistakes and speaking to people in a bad way. They should have thought about, actually, is the menopause having an impact on that? She told them that she was experiencing these symptoms. And what the tribunal said really was that they should have referred her to occupational health much sooner, because then occupational health could have advised on the further adjustments that could have been made. You know, she was asking for things like, could she have a break in between calls just so that she could kind of, you know, gather her thoughts, get ready for the next, if she was in a call centre. And they said no, they weren't going to do that. She asked for some refresher training because the menopause, I think, was affecting her confidence. And they said no, there's no budget for that. So, you know, things like that could have been potential adjustments that would have, you know, really made a difference to her and could have avoided that warning being issued. And occupational health, I think, is so important in those circumstances to really, you know, talk to the employee and make suggestions about things that could be done. The employer isn't required to, you know, to bend over backwards to do absolutely everything they possibly could do to create a new role or anything like that, but they are expected to give, you know, reasonable consideration to changes that could be made. And in this case, they just were very dismissive. And for a big company like Direct Line, you know, it's quite surprising that was their attitude. And I think that perhaps one of the things that this case highlights is, again, a real change in attitude towards menopause, whereas maybe even, I don't know, 5 years ago, it was kind of still a real taboo topic to, you know, women would sort of suffer in silence and wouldn't, you know, talk about things that adjustments that needed to be made. It's really seen by men maybe as, you know, just hot flushes and that's all it is. But actually there's so much more to menopause, and it can affect people in so many different ways. And so one of the key takeaways, I think, for me, and something that, you know, a lot of my clients are really starting to do, is look at training their staff about the impact of menopause on women, you know, and making that compulsory for men to go to, and understand, you know, that as a manager, people that you are working with may be experiencing these things, and there are, you know, simple adjustments that could be made, or at least just have a bit more consideration and patience, I think, for people. And the aggravated damages, as you say, in this case, are quite relevant. That's something that basically you're awarded where you've behaved in a particularly bad way, and the Employment Tribunal effectively want to punish you for it. And in this case, it was because they just refused to accept that she had a disability until right before the hearing, you know, whereas they should have been doing that during her employment. And it, you know, occupational health had said this lady may, you know, the impact on her may qualify as a disability. And so they just didn't take it seriously. They just kind of, you know, seemed to be very dismissive of it. And cases like this, are particularly large employer are ones that grab the headlines, when it's things like discrimination or harassment and things like that. That's the stuff that's reported in the press, and the impact on an organisation of, having these kind of things, written about them. It affects people wanting to do business with them. It affects staff wanting to carry on working there, attracting new employees. So, it seems like it's always easy to say in hindsight, isn't it, what you should have done. I don't know what you think about menopause policies, Trish. I think that's something that's kind of like a new area. We've talked already about policies today, and I think that it's not a requirement, obviously, to have a menopause policy in place, but it's something that some companies are starting to introduce. I don't know if you've seen that, or you advise your clients about it.
Yeah, I think it's a tricky one, because I think, in particular with this case, and to be honest, it's a bit of a trend, isn't it, with the things we talked about, is communication.
Yeah.
Pretty much everything I touch that where there's been a dispute is something hasn't been communicated properly, or you've not been sensitive to somebody. And I guess there's an argument that with menopause, actually, these people are going through symptoms that you could class with being unwell. So why wouldn't you treat them as though that's how, that's what they're going through, and be kind of mindful of that and communicate to them about that and look at ways that you can adjust their workplace. So part of me thinks, as a decent employer, you should just be treating this as an illness, and because that's the kind of symptoms that people are experiencing. So therefore, then, would you need a menopause policy? Don't necessarily know. But equally, I think it's important to also be clear with employees about how they're going to be treated when these things happen. So I'm not sure if I'm of the view that maybe it needs to be added into a sickness absence policy, or if it needs to be a separate thing. But I think there needs to be something. I think the debate's still open about kind of where it goes. But for me, treat people in the way that you would expect to be treated, right? If you were going through this, male, female, or whatever gender you are, how would you want a compassionate employer to respond? And I think it comes right back to your point of, you'd want them to be communicating, right? And talking to you about how they can support you. So I think if you, as an employer, if you root your response in that, whether it's written down in one policy or not, that's the key thing, because that's where it always goes wrong. It's that communication piece for me.
Yeah, absolutely. And I think from a employment tribunal perspective, that will, go so far in showing that you are a decent employer who has given due consideration. That if somebody's pouring their heart out to you and saying, this is how it's making me feel, and you're just dismissing it, saying, no, get on with your job, everyone else can do it, when you're not taking account of those personal circumstances. As I say, you're not expected to do everything that you possibly ever could do, but if you're talking to somebody about making some adjustments in line with the demands of your business and what you can reasonably do, then that you're acting reasonably, and the employee is much more likely to feel that they're being supported and valued within an organization, rather than probably in this case, I think she resigned and claimed constructive dismissal because she just felt that she was being forced out of the company because she was a nuisance, which no one should feel like, for going through something that 50% of the population are going to at some point in their life.
Yeah.
So menopause is a huge area. I think that we're going to see, this is one of the first cases sort of dealing with that, and so I think that it's certainly not going to be the last. There's going to be much more activity around this this year, in the coming years.
Yeah, I think for me, the key thing is, if you are going to be a decent employer, or you want to be a decent employer, then show up and be a decent employer. Do you
Definitely. Yeah. And don't just have, so often a policy. Yeah, we've got a nice menopause policy. That's nice to have, but you've actually got to live it. You've got to, and that's got to come from the top down, really. So yeah, be a decent employer, but don't just be a decent employer on paper.
Yeah, no tick boxing.
Yeah, definitely.
Oh, I'm kind of gutted that we've got to the last one, to be honest. This is really fun. But last case, we'll have to do this again because this is fun.
Yeah, absolutely.
So last case is about defamatory references, and I always think this is quite interesting because I tend to get like a range of references through and think, oh, probably wouldn't have done that myself.
Yeah.
But anyway, so this one is Smith versus Surridge and others, and this one centres around two teachers who apply for a new job at a school. Within the reference that's provided, it says that there were some safeguarding issues, and with kind of no other context around that statement. And obviously, the school then withdraws the offers of jobs, because who wants teachers where there have been safeguarding issues? Both teachers argue the wording and say that that suggests that they've mistreated students in some way, which they were asserting that they hadn't. And as part of the finding, there was a discussion around people would take the wording that was within that reference at face value. And because you take it as face value, actually that was a defamatory statement. What do you think, and what advice would you give to employers around how they should issue references and the kind of the importance of wording?
Yeah, definitely. I think that this case is a real kind of cautionary tale about references, and there's loads of misconceptions, I think, about giving of references as well. You know, I hear all the time, you can't give a bad reference. And that's not true. You know, legally, there is no obligation on an employer to give a reference at all, unless you're in certain sectors, say like financial services or, you know, teaching, that kind of thing. There's more of an obligation. But the giving of references, I think, has really evolved over the last, I don't know, 40 years, something like that. And the norm that I see now is that most companies now just want to give what we call kind of a standard factual reference, which is essentially, yeah, they worked there between this date and this date, and this was their job title, and we don't say any more than that. And that is exactly for reasons like this, where an employee could say, you've given me a bad reference and you've lost me a job. Or the new employer, if you give a glowing reference saying this person's wonderful and wouldn't hesitate to employ them and all the rest of it, the new employer then says, oh, I don't think we're talking about the same person. I only gave them the job on the back of the reference that you gave, and I don't, you know, we don't want to employ them anymore. So either way, because of the world that we live in where everyone wants to sue each other, unfortunately, the kind of the textbook answer has become just give a standard factual reference. You don't have to give a reference in most industries, but if you do, there is an obligation to not provide it, you know, misleading or untrue information. And so if you are just giving the facts of, yes, they work for us, this was the job they did, we don't say any more than that, then you're kind of, you know, sticking to the bare minimum. And I do see employees that I advise who've maybe worked for the same company for like 20 years who are totally shocked when they get a reference like that. And they're really offended, you know, and they say, well, I've done all this great work. And, you know, normally you'd give a real kind of rundown of the employment history and what they've done and, you know, their role within the organisation, which just isn't the norm anymore in terms of what I see. I don't know what you see, Trish.
Yeah, no, I'm a massive fan of a standard reference.
Yeah,
And if I'm, hopefully I'm not speaking for the whole of the HR profession, but if I see a reference that's got loads of detail and information in it, that's a red flag to me.
absolutely.
I just want to know, did the person work for you in the job that they were in from this date to this date? I don't even really want to know about salary or anything like that. That's all I need to know. So exactly the same as you, I've dealt with settlement agreements with clients where the individual's like, well, I want the reference bulked out more, and I'm saying, like, we can do that, but genuinely it's a red flag to somebody like me when I see that, because it says to me there might have been some sort of an agreement, or that there's not that there's anything wrong with going through an agreement, but it kind of insinuates that there might have been a problem. And equally, if not, then what's going on with this company's HR department? Not that that's my issue, but it is a bit of a flag. So yeah, I'm definitely a fan of a standard reference.
Yeah, definitely. I think the other thing is that it's important to have consistency in terms of the reference that's being given, and to make sure that you know who's giving the references, because sometimes, you know, people might say, oh, I'll ask my colleague, you know, to give me a nice reference, and the employer may have no idea that that's going out, but it's going out in the name of the company. And so there's a real risk then that, you know, someone might be given, you know, a glowing reference, and somebody just given that template's kind of factual reference, and then complain that they've been treated differently, and why is that, and have they been discriminated against? And I think in this case the reference was given by a PA to the head teacher, and really, you know, perhaps if it had been given by the head teacher themselves, that wouldn't have been the reference that would have been given. So again, the kind of awareness around who's doing what, making sure that you're consistent, training, maybe having a policy in terms of what the reference is, just to make sure that everyone's treated the same, and that hopefully there's not going to be issues like this. And I think that the other thing that people sometimes do is try and put some kind of disclaimer in the reference to say, you know, this reference is given in good faith, but we accept no liability for any reliance you might place on it. And some, you know, employers might think that's enough, that's going to get us off a claim like this, but it won't. You know, saying that is just, it's just words. And if you've said something that has affected someone's reputation, as in this case, then they're still going to bring a claim for defamation. Nothing that you put in the reference is going to change that. So I think, if you're giving references, the answer is be very careful about the information that you're disclosing, and don't, use it as a revenge, or to dish the dirt on everything that has ever happened. And in most cases, that standard factual reference is normally what I would advise as well.
Yeah, no, I'm totally with you on that. Thank you. I've really enjoyed doing this, and I'm genuinely gutted that we're stopping. How can people get hold of you if they want to get some stellar employment law advice?
Yeah, sure. So give me a call on my direct dial, or drop me an email, or find me on LinkedIn. Any of those.
Awesome. And I'll pop links to everything in at least YouTube or wherever I can, where we put this video. And apologies, my dog always has to join in with the podcast, so hopefully you haven't heard him, but he's been barking and snuffling, so you might have seen me looking away at times, like, oh god, so apologies for that. But
I didn't hear a thing, but it may have been because I was too busy waffling on about employment law.
Oh, that's awesome. Right, well, thank you so much for your time. I really, really appreciate it, and I am definitely going to hit you up to do this again because it was fun.
I know, I love it. Love a good geek off about employment law.
Awesome stuff.